The Liberals are pushing forward with dozens of justice reforms today, tabling a bill designed to make some bail harder to get and to keep some offenders locked up for longer.
That unfortunately there are some individuals who are so dangerous that society must be protected from them, and that we have to ensure that our law enforcement officials, our prosecutors, our judges, our courts, and our corrections facilities have the tools and the authorities that they need in order to keep our communities safe.
There's a lot of measures in this bill, but they include reverse onus bail for more violent or organized crimes where the accused must prove why they should be released. It would enable consecutive sentences for some violent and repeat offenders where the time they serve stacks. And it has new aggravating factors, which would mean harsher sentences for retail theft and crimes against first responders. This is the third time in a decade that the Liberals have attempted bail reform. So why do they think this attempt is going to be effective and constitutional? Sean Fraser is the Minister of Justice and Attorney General of Canada. Thanks for coming in. It's nice to see you.
Pleasure to be with you. Thanks for having me.
What makes you think that this time this bill and its expansion, this reverse onus bail, can survive a court challenge on charter rights?
Well, first, the process of engagement in the development of this legislation is what led us to adopt the measures into the bill that's now going through the House of Commons. We've taken in particular the perspectives of law enforcement organizations right across the country and provincial and territorial governments. These are the people who work within the system and the people who manage the systems to ensure that we're responding to the needs that they've raised when it comes to protecting public safety. My view is that we don't need to choose between our constitutional rights and public safety. We can operate within the boundaries of the Constitution and nevertheless advance measures that the police and the provinces are saying they need in order to help deliver public safety to the communities that we both represent.
Lawyer Lawrence Greenspan wrote this week that your reverse onus bail does violate the right to reasonable bail, saying there are, quote, few, if any, cases of people on bail committing violent crime, and that this, quote, disregards the presumption of innocence. What's he getting wrong?
Well, with enormous respect, there are reverse onuses that have pre-existed in the criminal law that have not been overturned for constitutionality. What we're trying to achieve is recognition that there are some offenders, particularly those who commit violent and repeated examples of their criminal behavior, that we need to address. I don't think it's too much to ask when you're dealing with somebody who's got a history of violence, who is contributing to very serious social problems that impact the public safety of communities, that they demonstrate why they should be released. They're going to be required to present credible information that will allow a court to say, we believe it's going to be safe to have you living amongst your community. From my point of view, this is something that we can do to give tools to the justice system, provided it's properly resourced by other levels of government who have that responsibility, to ensure that justice is administered in a fair and expeditious way.
These are pretty sweeping measures. Big net, it's going to catch a lot more people. How many more people will end up in jail on bail than there are right now?
Well, I think it's we have to be honest that when you look forward into the future, it's impossible to predict with certainty the precise number of people who might enter the justice system.
And yet, this is a measure you're taking to say, we think this group of people should not be getting bail. Do you not know how big that group of people is?
We do. So the point I'm making is that there are other factors that will play into how many people are actually facing bail. Because over time, if you make the investments in frontline policing that can help prevent crime in neighborhoods, if you make the upstream investments in mental health, affordable housing, youth programming, you can bring the level of crime down in the first place, which will bring the number of people who face bail hearings and sentencing down. This will likely result in a higher proportion of people who are facing charges, violent charges, and violent repeat offenders in particular. A higher proportion of them will likely be detained as a result of some of the measures that we're putting in place, or face stiffer penalties if they commit serious crimes. But the goal here is not simply to deal with crime after the fact. This is part of a broader strategy that's seeking to reduce crime in the first place. I
get that. But at the same time, if you're going to have stiffer bail conditions, steeper bail conditions, whatever you want to call it, provincial jails are going to have more guards. You're going to have to open up more beds. You're going to have there's a second step to this that has to happen, and they need to know presumably, how many guards they have to hire, how many more cells they have to have up and functioning, how much more food they have to cook. How do they prepare for that?
You're absolutely right. There are downstream impacts to the measures that you put in place on inside the criminal code in terms of the implementation, which largely falls to provincial governments. The good news is we've been working very closely with provinces. There is a level of collaboration I have not frankly seen during the entirety of my time as a minister in the federal government that went into the development of this bill. And I want to thank my provincial partners in particular who were asking for many of these changes. Given that so many of these changes were being requested by the provinces, they obviously know that they have a responsibility to properly resource the system to implement these laws. Part of the job has taken a meaningful step forward with the introduction of these changes in the bill that we've tabled in the House of Commons. But the job isn't done until we have a properly resourced system that can actually deliver on these. I have confidence that provinces understand the scale of the problem. I have confidence that they want to be a part of the solution. And I have confidence that they're going to make the investments necessary to help deliver when it comes to implementing these changes.
That sounds to me like you're saying this is their investment. They have to solve it. Will there be any money coming from the feds to try to help them get up and resource to deal with this?
There are continued areas of federal responsibility. Obviously, we have conduct of the criminal code. There's other conversations we need to have about the complement of federally appointed judges, which has an impact of federal contributions. Right. There may be other areas of collaboration where provinces, for example, collect data, but we may wish to be a good partner when it comes to developing systems that allow them to share that data. But we want it to start with making sure we're delivering on the responsibilities that we have in areas of federal jurisdiction. And provinces, from the conversation that we had in Alberta with all of our counterparts last week, indicated to me that they very much appreciate where their responsibilities are and also want to be part of the solution.
Just to pin you down, though, is there money coming to help these? Because provinces are as strapped as everybody else. Is there federal money to help them hire to address the increased demand that they're going to face?
Look, the spending that we would be looking at in the short term will be focused on areas where we have distinct federal responsibilities. I've outlined a few for you now. Yep. There will be areas that remain strictly provincially managed. And in those areas where provinces have responsibilities, we would of course expect that provinces make good on the need to fund those responsibilities.
Conservative justice critic Larry Brock told this show last week that your changes won't make, and I'm quoting here, one iota of difference. He's talking mostly, the Conservatives are very focused on the principle of restraint that needs to be repealed, not changed, is their idea. He also says the Supreme Court never told the Liberals that they should put that principle into law. You're sort of tweaking it a bit, but you're not getting rid of it. Why is that?
Look, just a couple of reflections in response. It's frankly unbelievable how routinely the Conservatives criticize something before they've actually read it. When it comes to the principle of restraint, what's gobsmacking about the statement that you've just read, suggesting that the court didn't tell the government to put it into law, the Supreme Court put it into the law. When the Supreme Court of Canada makes the decision, that is the law of Canada. But what's really important to understand, if you were to repeal the section of the code that has codified the principle of restraint, it doesn't go away. It's still there. If you actually want to have an impact, you can clarify how it ought to be applied. And that's what we've done with this law, saying very clearly the principle of restraint is not a get-out-of-jail-free card. It does not mandate someone's release.
But it's been interpreted that way in some cases.
I do agree that there are some cases I've heard about where it has been applied in a way that is different than what I would have intended when I first read the bill.
Right.
That's one of the reasons that I wanted to make changes to it, to clarify that it doesn't mandate release, and very specifically that a court must be satisfied they can manage the public safety risk before allowing somebody to be released back into the community.
I want to ask a bigger question about just kind of getting things done in this moment. This is the Liberals' third attempt at bail reform in, I think, 7 years. And one of the most constant complaints we hear, whether it's about housing that you've been involved in this, in almost every sort of facet of government, is that the Trudeau Liberals were really good at making big, broad, sweeping announcements on things, less good at actually getting in and getting the work done on the ground that allowed the implementation of those big ideas to get done. What is different now, and why should people believe that this time is going to be different?
Well, I can speak about my own experience in developing this piece of legislation. One of the things that has characterized the process to arrive at the bill that we presented in the House of Commons today is an unusual and frankly refreshing level of engagement with the people who work in the system and the people who manage the system. I have been speaking with the Canadian Police Association, the Canadian Association of Chiefs of Police, with the police in my own community. I've been speaking with my counterparts in every single province and territory to better understand where their priorities lie, and working alongside them, not just with an introductory call, but continuously taking their feedback personally and through our teams to ensure the decisions that we're making are going to reflect the needs of the people who know the system best. That level of engagement, that level of collaboration leads you to decisions that are going to have a more profound and positive impact on the public safety imperative, which is guiding the entirety of this process.
All right, we're going to leave it there, but really appreciate you coming in and answering our
pleasure
questions on this.
Anytime.
Justice Minister Sean Fraser.